All right, so we're on page 100. Finish up talking a little bit about the United Nations, and I think we were talking about Article 41 and 42 of the Charter. And just as a reminder, this is where we see within the Charter of the United Nations the ability for the Security Council to engage in either measures to enforce breaches of international peace through non-military force under Article 41, so that would be like economic sanctions, embargoes, trade restrictions, things of that nature. And then Article 42 is where we see in the UN Charter the ability for the Security Council, if they have determined that Article 41 non-military measures will not be sufficient or otherwise, then the Security Council can authorize military activity as necessary, which may include potentially sending in troops and use of armed force. So I put a star on Article 42 because I do have a very specific test question on the final. That's going to ask you which article within the Charter allows for the Security Council to allow for both non-economic and economic force, or non-military and military force, excuse me. So Article 41 is non-military, Article 42 is military. That's pretty much it in a nutshell. And then under Article 43, all members of the United Nations will contribute military support and other support as necessary to carry out the remedial measures under Article 41 or 42, up to and including providing military force, equipment, aircraft, naval ships and whatnot, and other various types of support, including rite of passage. So these three articles, 41, 42, and 43, are really where we find the enforcement capability of the Security Council and the United Nations. Now, with that said, again, you have to remember that the whole structure of the United Nations is post-World War II, meaning the Security Council permanent 5 members, including Russia, China, United States, UK, and France. Within that group of 5, you have, of course, the political issues, and so that in some ways, and this kind of depends on how you look at it, in some ways hampers the ability to engage in enforcement, because pretty much every time you have a situation which might lead to an enforcement activity, be it economic and non-military enforcement or military or quasi-military activity, you're going to have a power struggle based upon the politics within those 5 permanent members. And so there's a lot of discussion about that. Could that be changed? Could it be modified? And I doubt it under the current UN structure, and I'll show you why in a little bit. So you always have to keep that in mind when we look at the ability of the UN to engage in enforcement, the politics of the Security Council. All right, let's flip over to the next page here, just look at a few other little portions here. Article 44, when the Security Council has decided to use force, it shall, before calling upon a member not represented on it to provide armed forces, to participate in the decisions. So you're not going to force a country that's not otherwise part to engage unless they're part of the decision-making process. Under Article 45, in order to enable the United Nations to take urgent military measures, members shall hold immediately available national Air Force contingent for the combined international enforcement action. So that's sort of a quick strike capability. Again, one of the ideas of an organization, an IGO, is to provide a permanent, ongoing organization that's available to resolve issues. And so this is where we see within the United Nations Charter this idea of having ready to go, bags packed, ready to hit the door, running, wheels up kind of thing as necessary. Under Article 47, it establishes a chain of command, which is called the Military Staff Committee. and I'm not really going to go into the details of all that, but that establishes a command chain for military action and coordination of various armed forces under the United Nations overall control and command. And again, you've got to remember the background here. Members, when they join the charter, are, by becoming a member, are agreeing to this built in to the membership of being part of the UN. So that kind of implies also that you're, well, not implies, you are also then agreeing to the authority of the Military Staff Committee. All right, Article 51, down here at the bottom. Nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations. So this is preserving the fundamental right of self-defense of a sovereign. But there's a caveat here. Until the Security Council has taken measures necessary to maintain international peace and security. So the idea behind that language is to preserve the idea that a sovereign state or a collective group of states, maybe they're in a mutual defense agreement, they have the inherent right of self-defense. Nothing is taking that away. However, if a state or a group of states engage in self-defense through military force or otherwise, then the Security Council, the idea there is the Security Council at some point needs to take over that activity under the aegis of the UN Military Command. Now in the real world, of course, that doesn't always happen, but that's the idea and intent behind Article 51, to preserve that self-defense activity. Now, behind the scenes there, where does self-defense begin and where does it end? What about preemptive self-defense and all that kind of thing? I'm not going to really get into that in this class. It's more of a political science type class, but you know, there's a lot going on between these lines here in the real world, obviously, but on paper, at least, that's the idea behind this Article 51. All right, Article 52, kind of the same idea. Nothing in the present charter precludes existence of regional arrangements or agencies, including regional action, so long as they're consistent with the purposes and principles of the United Nations. So again, this allows for sovereign states to engage in collective defense and self-defense agreements, collective use of economic or military activity, so long as it's not contrary to the UN Charter. Again, the ultimate idea post-World War II is that use of military force should be preserved for self-defense or under the umbrella of the United Nations if military action, or economic action for that matter, is being used as an enforcement mechanism. All right, let's move on. I just want to point out kind of an interesting term here under Article 53, Part 2. The term enemy state applies to any state which during the Second World War has been an enemy of any signatory of the present charter. Now I just point that out, again, the idea, the whole United Nations Charter was designed and built coming out of World War II and the political powers that were in conflict at that time. Now obviously things have changed a lot since then. Germany and Japan are really allies more than anything, at least of the United States. And so a lot of that background is really somewhat moot or irrelevant now, but it's still kind of embedded in how the whole UN is structured. All right, a few more points here in some of the other organs. So another one of the organs is the Economic and Social Council, sometimes called ECOSOC, and the idea for Economic Social Council is, and I just want to point this out, to the principle of equal rights and self-determination of people, and as they spell out here, higher standards of living, full employment, solutions for international economic, social, health, and related purposes and problems, universal respect, observance of human rights, and all members pledge themselves to take joint and separate action in cooperation with the organization for these purposes. Now, the reason why I highlight that and point it out, on paper, again, this has been a fundamental shift post-World War II. The idea that individuals have rights under international law, even if a country is engaged in action that's purely a domestic matter, meaning within their own borders, not spilling out cross-border type of a situation. But even then, individuals have right or standing to a degree under international law, which historically has really never been the case. Now, how far that goes depends on the case, but I point that out because that's where we see it on paper as sort of a fundamental shift in the theory of international law. Okay. Okay, Economics and Social Council, under Article or Chapter 10. Economic and Social Council shall consist of 54 members of the United Nations. I'm not going to spend a lot of time on it, but basically the Economic and Social Council, ECOSOC, is like the administrative arm and coordinating organ of the United Nations, very similar to what we would look at as the administrative agencies within our own federal government and state government for that matter. This is where we find a lot of the social service type organizations and the coordination among them. And again, down below here in Article 62, that phrase again, Economics Social Council may make or initiate studies and reports with respect to international economic, social, cultural, educational, and related matters, and may make recommendations. There's that term again. We saw that term with the General Assembly. We see that same phrase with ECOSOC. And again, the idea being that ECOSOC does not have legislative-like authority, nor does it have administrative rule regulatory-like authority, but they do have the ability to initiate and formulate international law in other ways. While they cannot mandate it, it is a fundamental part of the Economic and Social Council to engage in progressive development of international law through initiating studies, treaties, conventions, cooperation among both IGOs and NGOs with the UN, and those types of activities. That includes, right here, very specifically, the ability to prepare draft conventions for submission to the General Assembly, and may call on United Nations members in international conferences. So right here, it's on paper, one of the ideas behind ECOSOC is to initiate these conventions. Remember, a convention is essentially a large treaty involving a specific area of international law. And so, you know, if I ask you a question, can the United Nations create international law? Well, yes and no. No, in the respect that neither the General Assembly nor ECOSOC have the ability to legislate. But the UN does have the ability, sort of collaterally, to be able to make international law through treaty making, initiation of conventions, progressive development of international law, creating an international forum which can lead to a type of customary international law. So the yes part of that question is, yes, the UN can, in a way, create international law, but not through what we would traditionally view as how law is made. It's done sort of more in the background by initiating these things. It's still up to the member nations to join on to treaties and conventions. And so that part of traditional international lawmaking is still very much in play. But we see this idea of one of the fundamental goals of the UN behind the scenes is to lay the foundation or framework, or however you want to phrase it, towards the idea of creating treaties and conventions and whatnot. So yes, the UN can make international law, but it's done sort of in a roundabout way, I guess is the point I'm trying to make. All right, let's move on. I want to get through this so we can start talking about the WTO. Okay, chapter 12, excuse me. Trusteeship system, I've talked about this already. All I want you to know about the international trusteeship system. This is one of the organs of the United Nations that was established for the purposes of providing the ability to, post-World War II, there were areas around the world, primarily in the South Pacific, that didn't have really any functioning government whatsoever, and not really even a nucleus of a functioning government. And so the idea was to create a trusteeship system to allow the UN to engage in a form of governance within those areas. It now really is no longer functioning. If it ever will function again is not really known. But that was the idea behind that. I do have a test question where sometimes it comes up on my, I have like a program where I push a button and it randomizes the questions. I have about like 400 questions that it picks from, right? And so I do have a question, which organ of the UN is no longer functioning? That's a loaded question, but the idea there is the Trusteeship Council, okay? All right, let's move over to chapter 14, International Court of Justice. All right, chapter 14 creates the International Court of Justice. We've talked about it a little bit, the ICJ. I'll use that abbreviation quite often. So the International Court of Justice is the principal judicial organ of the United Nations. It shall function in accordance with the annexed statute of the International Court of Justice, which we'll get to, which is based upon the statute of the Permanent Court of International Justice, which was the background from the League of Nations. So the precursor to the UN was the League of Nations, established post-World War I. And as part of the League of Nations, they had the Permanent International Court of Justice. And then that basically became what we now know as the ICJ, or the International Court of Justice under the UN Charter. All members of the United Nations are, here's a cool term, ipso facto, parties to the statute of the International Court of Justice. So what does that mean? Anybody know what ipso facto means? In and of the fact, or in and of itself. The fact of being part of, so in and of itself. So all members, in and of itself, by being members, are automatically part and party to the International Court of Justice. By being a member, you are also, with some exceptions, agreeing to the jurisdiction of the International Court. So again, that's one of the behind-the-scenes ideas of the obligations, and also the rights and obligations that a member has when they join the United Nations. And part of that is they have the right to petition the court if there is a dispute, and also the obligation to respond if they're accused of violating international law in a contentious case before the court, and then also to carry out the decisions of the court, which may include enforcement action through the Security Council to enforce court decisions as applicable. So there's a lot going on in that one sentence. Number one, the members are agreeing to the jurisdiction, the authority of the court. I mean, that's a big deal. You've got a sovereign state now agreeing to be under the jurisdiction of an international court, and agreeing to carry out the decisions of the court, and if they're a party to the action, to agree to the decision without appeal, basically. So that is a huge change in traditional historic international law. And again, this is the idea, the theme throughout, which you're probably sick of me saying. The idea to change from rule of force to rule of law. Part of rule of law is the judicial process. That is, having courts and judges and tribunals and other non-armed conflict type things use those processes to resolve disputes rather than force, economic or military or otherwise. Part two, a state which is not a member of the United Nations may become party to the statute of the court, meaning that if a non-member state is involved in a dispute, the non-member state may also appear at the court even though they're not a member of the UN. Now, the Court of Justice may impose conditions on a non-member state participating, but it's not, and was designed not to be in a closed manner to prohibit non-member states. In fact, it's encouraged that non-member states, remember post-World War II, if there were disputes, to take it to the Court of Justice rather than military or economic force. So test question, true or false? Only members of the UN can be part of the International Court of Justice proceeding. The answer is false. Non-member states may also take part under conditions established by the court. All right, Article 94. Each member of the United Nations undertakes to comply with the decision of the International Court of Justice in any case in which it is a party. Repeating myself, but again, part of the rights and obligations of being a member. In this case, it is you are agreeing that you must comply with the court's decision. Now, again, you're a sovereign state. You now have a court, 15 justices telling a state what to do. Does it always follow through in the real world? Not necessarily, but there on paper, that is one of the obligations of being a member of the UN, to carry out the decisions of the court when you're a party to the dispute. If any party to a case fails to perform the obligations incumbent upon it under a judgment rendered by the court, so they don't follow through with the court's decision, the other party may have recourse to the Security Council. So here's where we see an enforcement mechanism on paper allowing for the Security Council, and this may include Article 41 or 42, more likely Article 41 sanctions, in the event that a state is not carrying out the judgment and not following through on the court's decision. Nothing in the present charter, Article 95, nothing in the present charter shall prevent members of the United Nations from entrusting the solution of their differences to other tribunals by virtue of agreements already in existence or which may be concluded in the future. Now, I point that out because this is saying, in plain language, that the charter is not going to prohibit other dispute resolution systems. For example, the World Trade Organization, as we start to talk about it over the next class or two, has a built-in dispute resolution system for WTO members. And we see the same idea in a number of other treaties and conventions where built into treaties and conventions are dispute resolution mechanisms that deal with the topic of the treaty. And in fact, that is encouraged to have those type of systems put into place as part of multilateral treaties or conventions. So the idea is that the UN Charter and the Court of Justice is not intended to be the only method of non-forceful dispute resolution. And like I say, it's encouraged. All right, Article 96. The General Assembly or the Security Council may request the International Court of Justice to give what's called an advisory opinion on any legal question. And I talked about this a little bit last time, just briefly, but basically the International Court of Justice has the ability to handle two different types of cases. One type of case is what's called a contentious case, and that's when states or a group of states have an actual dispute between or among them. So there's an actual dispute involved. An advisory opinion is when there is some sort of question of international law or fact that's not necessarily a dispute, but there needs to be guidance that is provided to the General Assembly or the Security Council on what and how international law should be interpreted. And it's not an actual dispute. We have a similar thing in domestic law, which is called the declaratory judgment. That's where a judge will make a decision about a legal question, although this is much broader in scope than that type of thing in the domestic law. So this might be a situation where there's a question on whether or not a certain practice rises to the level of being a peremptory norm of international law, or jus cogens, or a matter of customary international law, or something like that. All right, the Secretariat. Secretary General is the Secretariat is the administrative agency of the United Nations, and the chief executive officer is called the Secretary General, who is the chief administrative officer of the organization. Essentially, it is like a president in a way, or a prime minister kind of, but really without executive authority, enforcement type authority, with one exception, right here under Article 99. One of the powers of the Secretary General, and this is one person, keep in mind, the Secretary General may bring to the attention of the Security Council any matter in which their opinion may threaten the maintenance of international peace and security. Now, the reason why I highlighted that, again, back to the idea of why have intergovernmental organizations to be in the first place, and this is the idea that you have a permanent forum which can allow for hopefully dispute resolution at the point before it turns into something really bad, to put it in plain language. So this gives one person the ability to go to the Security Council. Normally you'd have to go there from the General Assembly. And so, you know, if there's a problem that develops overnight, you can make one phone call to one person, the Secretary General. The Secretary General can then initiate a meeting of the Security Council as a streamlined process. Now you can imagine, again, reading between the lines here, there's a lot of politics involved in that. And you know, the Secretary General is going to have to make a decision if it's something worth taking up to the Security Council. But this is one way in which we have direct enforcement power by the Secretary General. Secretary General in and of himself don't have enforcement power, but can initiate it through the Security Council. With that said, the Secretary General also plays another role, and that is of a diplomatic role. And that can often lead to, from a dispute resolution standpoint, I'm going to write a term down here for you, which I use somewhere else. Where's my pen? Okay, I apologize for my bad handwriting. The phrase good offices. This is a term that's often used to refer to when a person who has a position of authority engages in negotiations and diplomatic type activity in a dispute resolution situation. It's like acting as a mediator to a dispute, a neutral third party, and it's often said that when a person that has that kind of a position is engaged in that type of activity, they're using their good offices. The idea being that the position itself, not necessarily the person, but it could be the person as well, but the position itself, the office of the Secretary General, in and of itself carries weight of authority. And that weight of authority, in a diplomatic sense, the Secretary General often will act as a facilitator, mediator, diplomatic liaison, however you want to phrase it, and basically, try to work out a deal as a facilitator. So countries may have a dispute that is bubbling, if you will, and the Secretary General doesn't have enforcement authority, but may act as a form of a go-between to try to resolve the dispute before it goes any further. And then we say that that person is using their good offices. Now that could apply to any type of domestic or international position. It could be the President of the United States or the Secretary of State for the United States, or it could be a Chief of Staff, it could be a Prime Minister in another country. Anybody that has that kind of, a religious leader of some type, anybody that has like a position of authority utilizing that gravitas to try to resolve a dispute. That's the phrase we use. Okay, kind of got aside there a little bit. All right, next page over. Article 100, Section 2, right here. Secretary General still. Each member of the United Nations undertakes to respect the exclusively international character of the responsibilities of the Secretary General and the staff, and not to seek to influence them in the discharge of their responsibilities. So again, I highlight that because behind the scenes of that language, what's going on, this is the UN Charter essentially saying that the Secretary General position on the world stage is of an international quality. And along with that position carries sort of a authority, I'm not sure that's the right word, but basically the idea that as an administrator for the UN, that office, the members of the nations need to respect the office and not, well, like it says here, not engage or undue influence behind the scenes. But it's really more than that. It's the idea that sovereign states need to, almost like the way that a president or other chief of state would give respect to another chief of state, kind of at that same level. I'm not sure quite how to describe it, but essentially the office carries with it the same sort of political or international characterization like you would a head of state for a country. And it's recognized that way. All right. Miscellaneous provisions. 102. Every treaty and every international agreement entered into by any member of the United Nations after the present charter comes into force shall as soon as possible be registered with the Secretariat and published by it. Now I point that out, again, this is one of the functions of an IGO, in that we see the same thing with the World Trade Organization and the European Union for that matter. But here the idea is that one of the ideas behind an IGO is to function as a repository, a library, however you want to phrase it, whereby international law can be deposited, put on file for a matter of transparency, for legal research, so other countries know what treaties are in place. And that helps, the idea being that you have that disclosure of these agreements and regional arrangements so that countries have the ability to know what agreements other countries have in place or have agreed to. It's a matter of transparency. No party, under Section 2, no party to such treaty or international agreement which has not been registered under this article may invoke that treaty or agreement before any organ of the UN. So this is giving some weight behind the requirement to file treaties. And essentially what that's saying is if a state fails to file a treaty with the UN, and then that state wants to go to the General Assembly or the Security Council or the International Court of Justice for that matter, and rely upon that treaty that has not been filed, they may not be able to do so. So that is a sort of a penalty for not registering the treaty. In the event of a conflict between the obligations of member nations under the UN and their obligations under other international agreements, the obligations under the present charter shall prevail. This is sort of a supremacy clause kind of paragraph. In other words, the UN Charter is intended, by becoming a member, to be at the pinnacle, if you will, of international, intergovernmental organizational law. Similar to what we see in our U.S. Constitution, the supremacy clause, which makes federal law supreme over state, city, or county law. Same kind of idea. Number 104, Article 104. The organization shall enjoy the territory of each of its members such legal capacity as may be necessary for the exercise of its functions and fulfillment of its purposes. What does that mean? Enjoy in the territory. This means that, to put it sort of plainly, UN functionaries, which may include military, economic, social, health, other type of activity of the UN and their affiliated agencies, may enjoy the territory. That means enter into the territory of another sovereign and carry out their activities, and along with that provides a level of sovereign immunity like we would see with diplomatic immunity or other type of immunity of a state. This also is an obligation. Remember, a member is agreeing to this, that they will allow UN activity within their territory. Article 105. Well, it's the same, these two kind of go together. Organization shall enjoy the territory of each of its members' privileges and immunities, which is essentially rights, to carry out the activity of the UN. All right. Next page over. Chapter 18, Amendments. Article 108. Amendments to the present charter shall come into force for all members of the UN when they have been adopted by a vote of 2/3 of the members of the General Assembly and ratified in accordance with their respective constitutional processes by 2/3 of the members of the UN, including all of the permanent members of the Security Council. So if you're going to amend, this is what I was getting at earlier. If you're going to change the structure of the UN and amend the charter, there's a two-step process, well actually a three-step process. Number one, the General Assembly by a supermajority vote, 67%, must agree to amend the charter. It must then be ratified by 2/3 of the member states within their own domestic law. That's two different things, including all of the permanent members of the Security Council. So what does that mean? That means that essentially in order to amend or change the structure of the UN, it's going to require all 5 members of the Security Council that are permanent, US, Russia, China, etc., to agree. Now the problem, of course, is getting that agreement. It's going to be very difficult, not to mention a supermajority vote. So this whole idea of modifying or changing the whole way the UN is structured in that respect is really unlikely, just because it's just, as a practical matter, almost impossible that that could occur, at least under the present environment of things. So, okay, that just follows up with that. All right, so let's talk about a few other things. I just want to show you page 112. I'm not going to spend a lot of time on this, but this is sort of a flow chart of all of the different organs and the affiliated different specialized agencies and other IGOs and NGOs. And I just want you to kind of get an idea of the scope and number of all of these different subsidiary agencies. So we have the principal organs here over on the side, General Assembly, Security Council, etc. And then these are the interactions that they have with some of the other programs, funds, commissions, IGOs, etc. So we have, under the Security Council, subsidiary bodies there, which it's hard to read there, but counterterrorism committees, International Criminal Tribunal, and then we have here under Economic and Social Council, you have the various different programs and funds. United Nations Conference on Trade and Development, International Trade Center, which includes affiliation with the World Trade Organization to coordinate international trade, UNICEF, United Nations Children's Fund, United Nations Office on Drugs and Crime, and then a lot of these other subsidiary bodies. Now, again, the reason I'm pointing this out is twofold. Number one, this is where we see behind the scenes a lot of the administrative activity of the UN, but also leads to the development of international law through the work of the agencies in formulating treaties and conventions and in customary international law. Other commissions down here, which tie back to ECOSOC, various different regional commissions involving different continental areas, Africa, Europe, etc. And then we have the specialized agencies over here. A lot of these you've probably heard of. International Monetary Fund, which is a separate IGO in and of its right. Actually, all these are. WIPO, World Intellectual Property Organization, which deals with international patent, trademark, copyright law, registering an international patent. That's, you would go to WIPO to do that. International Development Association, World Health Organization, obviously, everybody's been reading about that. So, all ties back to the UN, all the fingers all throughout all of these different things. All right, enough on that. So I want to point out, we've got a couple other pages here. Page 121. So this is the United Nations Office of Legal Affairs. And I printed this is right off their website, but I put this in the book just because kind of a background thing. You don't hear about this a lot in the news or anything. But going on in the background, Office of Legal Affairs acts as a sort of what we would call like an attorney general type role for the development of international law, the coordination of international law. So here you see, like right down here, if you want to research treaties, here's where you would go if you wanted to look up treaties that are in force from a legal research standpoint. They have various different sources here, including you can look up International Court of Justice case law and decisions made by the court, sort of a law library type activity. Here is the Codification Division, and again, codification is the writing down, putting into writing customary international law, and that's their role there. So, an administrative thing, the International Trade Law Division, and the treaty section. So, international trade, which may include the Convention on International Sale of Goods, international wiring and deposits of banks, a lot of things that we don't really think that the UN's involved with going on behind the scenes. Now, again, what does this relate to in terms of this class? This is how, even though the UN cannot legislate, it does play a huge role in the creation and development of international law behind the scenes by initiating and coordinating all of these activities. The harmonization of international law. Likewise, next page over, UNCTRAL, United Nations Commission on International Trade Law. And this is another legal body of the United Nations, again, that kind of functions behind the scene. Where's my... I have my highlighter here, so I'll just underline it. Core legal body of the United Nations system and development of international trade law, which includes the modernization, and here's that word, harmonization. Harmonization means bringing the country's internal laws into harmony so they're the same. Harmonization of international trade rules, international transactions, import and export law, shipping, customs procedures, environmental standards, engineering standards, letters of credit and other financial instruments that are used in international trade. We'll talk about letters of credit later on in the term. And so this is where we see this idea behind the scenes in terms of international business and where the UN is involved through UN Control to establish these things, which may include conventions and model rules and law and other type of technical assistance. And I'll just give you a real world example. If I'm writing an international sales contract for a client as a lawyer, I can go here and they have literally paragraphs that I can cut and paste into my contract. In some cases they have model contracts forms, basically legal forms, that I can use in multiple different languages. Sometimes they have forms, if I have, let's say I'm doing business with a French company, they'll have a contract language that's in English on one side and French on the other. So it's the same thing, it's just been translated. And so this is where, as a practitioner, a person can go and find forms, find paragraphs that deal with international arbitration and dispute resolution, international transfer of funds, all those kind of practical, everyday kind of things. So you don't see that in the news very often. It's going on behind the scenes, but a very practical function of the United Nations in terms of international business law. Next page over, here's some specific examples. So international commercial arbitration and conciliation, this is on page 123. So that is international arbitration is having a private judge resolve a dispute on an international private dispute like a sales contract or something. And these are rules that can be adopted in a contract so that the parties, a French company and a United States company can agree ahead of time. If they get into a dispute, they're not going to go to court. They're going to use an international arbitrator to resolve the dispute. And then they have paragraphs that can be put into the contract that talk about how do you initiate the dispute, how do you provide notice and service on the other party, where will the dispute be handled? Will you do it by Zoom, literally? Or will you have an actual live meeting, maybe in Paris or New York or Sydney, Australia, or wherever it may be? International sale of goods, the CISG, we'll talk about that a little bit later in the term as well, but this is a convention on the international sale of goods, which is essentially international law on the formulation on how contracts are formed. And it basically is a default. So if you have companies that are from different countries and they have, French law versus United States law is very different in terms of contract law. Well, they may not want to apply US law or French law, so they'll agree to apply essentially international law, which is created by the United Nations. And that's on things like warranties, providing refunds, stuff like that, just sort of practical, everyday kind of things. Security interest, that's where you are loaning money and if you want to be repaid, a company doesn't pay you, you can go repossess assets. Maybe it's a ship or an aircraft or containers, shipping containers, or other assets which may be anywhere in the world depending on the day. And this allows for the international registration of what's called a security interest, so that it tells the whole world that you have first rights to that asset in the event of a default on a contract. International payments, international transportation of goods. And so these are all conventions, texts, treaties that deal with international trade law. Now again, I point that out twofold. One, you just don't hear about it very often in the real world. But two, this is how, again, we see the United Nations have this ability to create international law, to create standards, even if they cannot legislate. That's kind of my whole point. All right, hold on just a moment here. Okay, page 128, I've already talked about this, but I just want to little bit plain language. International Court of Justice, primary court of the United Nations, we've talked about all that. So the court has two kinds of cases that it will handle. The first is disputes between states. We call that contentious jurisdiction. And advisory jurisdiction. That's where another organ of the UN, the General Assembly or Security Council, may ask the court to give an answer to a legal question. So I highlight this slide because I have a test question that sometimes comes up that basically asks, what are the two types of cases that the International Court of Justice has jurisdiction? Number one, an actual dispute called contentious jurisdiction, and that's the term I use in the test question. And two is advisory jurisdiction. So that's where you find the answer to that question. And then next page over, here's the definition for that. Contentious jurisdiction, the power of the court to hear disputes between states. One of the prerequisites, a state must recognize the court's jurisdiction. That is usually done by being a UN member or perhaps a non-member agreeing to the jurisdiction, or it may be included in a treaty, whereby if there is a treaty that says any dispute will be referred to the ICJ, or what's called a unilateral declaration, meaning a state may say, we agree ahead of time in any dispute with any other country, be it a member or a non-member, we will agree ahead of time up front to appear with the International Court of Justice. That's called a unilateral declaration. Yeah, the rest of this I'm not going to really get into in this class. I just want to show you a couple other things here. Page 131. Advisory jurisdiction. This is the second type of case. It's the power of the International Court of Justice to give opinions about issues of international law at the request of the UN or other specialized agencies. Note at the bottom here, a case that is up for an advisory opinion will be rejected by the court if it is viewed that the effect of making the decision would create a dispute. It's kind of hard to put that in plain language, but this is the idea that you don't want states to try to strong arm or utilize the Court of Justice in a way to gain leverage or an advantage in a situation that could lead to an actual dispute. In other words, they don't want to create a dispute where there is none. And so this is a fine line. It's up to the court to make a decision if they even want to handle the case. We have the same rule in domestic law. I can't really think of an answer or a situation right off the top of my head, but that is one of the caveats there. And then the next slide down. Decisions of the International Court of Justice are binding between the parties with respect to a particular case only, meaning that the court decision only is applicable to the actual parties in the dispute, not to other countries that are not part of the dispute. There are reasons for that. One reason is the law that may be applied in that particular case may be based upon a treaty that only involves those two states or maybe a small group of states and maybe not necessarily other countries. Or it may be that in that unique case, they're applying the law of one of the countries that are part of the dispute, and so that law may not apply else outside. The concept of stare decisis does not apply. This is, stare decisis is basically what we would call precedent. Like here in the United States, we have the doctrine of stare decisis means to stand on previous decisions. Plain language, this is previous court decision. is binding in the future on other courts. Like the U.S. Supreme Court, when it issues a decision, every other court in the United States must follow that decision by law. Different international law, it's not going to be binding in the future. However, it is given a lot of authority. But it's not like a U.S. Supreme Court decision that is mandatory binding on all lower courts. Judgment is final and without appeal, and that's primarily because there's nowhere to appeal it to. However, the International Court of Justice may review and interpret a judgment if it's unclear or if circumstances have changed, or the court may revise a judgment if it's requested by the parties within 10 years or within 6 months of discovery of something that's new, relevant fact that wasn't known before. So in other words, they have the ability to adjust or modify the decision, but there's no appeal per se to a higher level court. Next page over. Compliance. Theoretically, as I've shown you already, Security Council has the authority to take measures to give effect to a judgment, that is to carry out and enforce a judgment. However, even then, as with any other Security Council activity, on paper they may have that authority. In reality, whether or not the Security Council does anything, again, remember, all 5 permanent members must agree. And so I want you to think about that for a minute. So we have the International Court of Justice making a decision, applying it to the parties to a dispute. One of the parties is in breach, default, not carrying out its requirements under the decision. It's then referred to the Security Council for enforcement, which means that all 5 permanent members must agree on that enforcement. Now, what that also means in the real world is all 5 members of the permanent members essentially have veto power over the court, right? In a manner of looking at it. So if the court makes a decision, the country's not following it, you go to the Security Council for enforcement, but one of the 5 permanent members, or more than one, does not agree, no enforcement. So it's sort of, in some ways it's a check and a balance, but in other ways it's essentially the ability to override the court in a way. And that's back to the whole structure of the UN to begin with, and we've talked about that already. Okay, what time is it here? Okay, so I'm going to stop my